Welcome to the Krinzman Property Playbook, your inside look at South Florida real estate. I'm your host, Matthew Krinzman, bringing you real strategies, real insights, and real connections that help you buy, sell, and invest with confidence. With over 2 decades of experience as a licensed realtor and broker associate, I've watched South Florida grow from a quiet getaway to a global destination, and I'm here to help you navigate it like a pro. My business thrives on trusted relationships, with many of my clients being repeat and referrals. This podcast is brought to you by me, Matthew Krinzman, a Sotheby's International Realty agent. For more info, visit buysellmiamire.com. Let's dive in.
Hello, everyone. My name is Matthew Krinzman. I am the host of the Krinzman Property Playbook. As a host, I am also a broker associate here in South Florida with Sotheby's International Realty. Been doing it for a long time. And today I have Lauren Alexis Klein. You like the whole name, or is it just Lauren Klein good? I sometimes don't want to misname you.
Either way is fantastic.
Okay. All right. So Lauren, you are an attorney with the Flourish, right? Okay.
Flourish.
Pronounce that right?
You
Flourish
got it.
Law Group. You have offices in St. Petersburg, for those who call St. Pete of Florida. And then you're down here in Fort Lauderdale, in South Florida, along with where I am. And tell us a little bit about yourself. I always like to hear about the journey of how you got to what you're doing.
Yeah, thanks for having me on the show. I'm excited to be here today. A little bit about my journey. So I am a tax and a trust and estates lawyer and fell into this area of law and really law in general. I was actually a finance major interning at one of the big brokerage houses, but the year was 2008.
Oh, God.
Yeah. And so the broker I was working with was like, look, you might want to do something else for a little while. Good advice. Yeah. And I thought to myself, I always thought about law school, that it might be in my future. And I figured now is as good a time as any to bide my time while the economy recovers. So went into law school. That's when foreclosures were like the hot thing and everyone was doing internships related to that. And I thought, I tried that, but I was like, that's not what I want to do. I love real estate, but that wasn't really the direction I wanted to go in. And then I took a wills and trust class. Really loved it. Something clicked. And then I took a tax class, which surprisingly also really clicked. And I had this 24-year-old me epiphany of, finance, wills and trusts, real estate, it's all interrelated. I'm going down the same path, just from a different perspective. So that was a big aha moment for me. Had a professor who encouraged me to then go ahead and get a master's in taxation, which is in the legal world, an LL.M. So went ahead and got that, started my career in Big Four public accounting, which half of my LL.M. class did because the economy was still not too hot. So started with Deloitte, quickly realized I wanted to work with families rather than big Fortune 500 corporations.
You didn't want to be a consultant.
Yeah, exactly. So went into private
practice. You want to consult in a different way.
Exactly, 100%.
Good for you.
Yeah, thank you. Yeah. So took it in a different direction, and here I am today. Was in big law for many years, about to make partner, and decided to go off on my own.
Yeah, I saw that you were with, was it Holland and Knight at one point?
Yes.
Which is a big firm here in South Florida, well known, respected, and kudos for you being on that track. But you decided to go off on your own. And I have a lot of friends and family who are attorneys, and a lot of them have gone off on their own, hung out their shingle on the storefront and to strike out on their own. Is why did you decide, hey, I'm going to leave such a prestigious big law firm and go out on my own? What was the idea behind it, or the thought process?
Yeah, so there was really 7 big kind of factors, I would say. One is when you're at that level, you're really working with the top 1% of the top 1%. So all of my clients really had in excess of $30 million plus for it to make sense for them to work with Holland and Knight, which was great. Mm-hmm. But I thought to myself, there are so many people in South Florida, all of Florida, who have great assets, maybe real estate portfolio, whatever it might be, businesses, where they don't need that big law kind of environment. They just don't need that, but they need access to high quality legal services, to tax planning, all of that. And so I thought to myself, wow, I could offer what I've learned and my skills in more of a boutique fashion and help more people, and more people who were like me. That was a big driving factor. And then another one was I was on the precipice of applying for partnership. And I looked around and I thought to myself, okay, where do I want to be in 5 years, 10 years, 15 years? Is this really where I want to be? Is this where I see myself? And I could have stayed and had a fabulous career, very lucrative career.
Yeah.
But it just wasn't the right fit for me. It's the right fit for many people. But for me, I just thought I see myself more in building something of my own, using technology in ways that maybe aren't always utilized in some of the bigger firms. Law is slow to move, and trust and estates, I think, is the slowest practice area to move. So yeah, I really wanted to build something of my own and create a firm experience and environment for our clients that suited who I was as a person and as an attorney.
So you had that entrepreneurial spirit at heart to go out on your own, create something for yourself, obviously, and you have a law partner as well that works with you. Congratulations on being an entrepreneur in that respect. It's not easy. Look, real estate agents, for the most part, and brokers, we're self-employed for the most part, and we are entrepreneurs at the end of the day. We're working for ourselves, or we have some of us have teams. We're working for the team is working for us, and it's a business at the end of the day. Law is a business. I've heard that plenty from my friends who are attorneys, and my brothers are attorneys. I understand how it works, and congratulations going on your own and actually building, from the looks of it, a pretty successful niche practice that you have for yourself in the estates and planning. You said something, I don't know if I want to come back to it later, but maybe right now is a good time as any. You said, and I really want to hear more about that, because obviously technology is we're surrounded by it. Obviously, we are embracing technology as we speak. You're at your home, I'm in my office. AC is not working, but I'm powering it through it. Yeah. And you said like law is like a slow adapter when it comes to technology. And real estate was, for a long time, was also a little bit of a slow adapter when it came to it. But now we're light speed ahead. I think every day, especially with AI, the advent of AI. I just was really curious to hear more about you and what you mentioned about technology. I just would love to hear more about that.
Yeah. And I just want to caveat, I am not an expert in technology by any means. My law partner, I would say, is light years ahead of me. But the way that I looked at it back when I was in Big Law was, okay, it feels like every time we get a new client, we're starting from ground zero. We don't have a process. We don't have a structure to have a seamless intake that doesn't just rely on us as human beings, right? And so
Understood.
As we've built our firm, and we're constantly, even today, we were in a meeting this morning about how better to utilize ChatGPT in our business and all of that. But I just thought there's got to be a better way. So as we've built our firm, we've been very intentional to try out as many different technologies as possible. One, to make our jobs easier, but also to make us more efficient so we can be more profitable and also more affordable for our clients. Because a lot of people, when they see the price of estate planning, they get a little bit of like a sticker shock.
Yeah.
And when we explain everything that goes into it and the benefits and what it really prevents on the back end, incapacity or death or tax implications, asset protection, then they start to go, oh, I just didn't really understand what the planning entailed. But what we've really done is we've tried to make the process seamless for our clients. So we've built in a lot of automations on the back end. So we're not just relying on ourselves to do follow-ups or whatever. And everything's very customizable. We have a very close relationship with our clients, but there's just some things we don't need to do. We have an intake form that's all through software that then ties into our CRM. That I did not have anything like that in Big Law. I'll be honest, we had a PDF that the client had to print out, fill out, scan back in. And I'm like, this is crazy. This doesn't even make any sense. So everything that we've tried to build and continue to build just makes it easier for our clients, makes it easier for us. And I think especially as AI develops, maybe we'll even develop actual drafting for the clients so it can become even more affordable, especially for those who don't need an overly sophisticated estate plan. So it's been a lot of fun to learn. I'm an elder millennial, but I'm still like not a super techie person. So it's been fun to learn and improve, and sometimes fall flat on our face or want to throw our computer out of the window.
I know the feeling. You look at it as a Gen X alumni. I'm not a quick adapter of technology, but once I do, I get into it and it's fun. Like you're talking about the AI, especially how it can streamline your business, my business, especially with database and CRM flow and keeping up with the clients. And like you said, you're creating some processes that could make it less expensive for the clients you're working with because they not be at a higher bracket of income or wealth, but they need your services, and you're making it affordable and you're making it accessible for them, which is great. I love that because sometimes people, like you said, people get frightened by the price. They get the sticker shock. And that's the same thing in real estate. A lot of times when you're dealing with some of the largest purchase that most people are ever going to make in their lives, and then they start, maybe I can save money on my inspection. And I'm like, no, don't. That's not where you want to really try to save money on. Things like that, you want to spend the money because you know what you're buying and what you are getting into. So the same thing with law, and same thing with you when you're dealing with a person, a legal attorney or a lawyer who's helping you protect your assets. Yeah, you definitely don't want to cheap out, but at the same time, you want to make it. I see where you're coming from. You want to make it accessible for most people to be able to do what they need to do to protect their assets. So let's get into that. Let's get into the assets protection. There is a link that I deal with a lot on real estate and estate planning, because people, depending on where they are in lives, young or old, they may have accumulated some assets in real estate and they want to protect it. They want to keep it in the family, or maybe figure a way to disperse it when they're gone. And it's all about asset preservation and asset protection. So let's talk about that. The homeowner, why having an estate plan is important.
Yeah. So starting with the home, it's so important that when you do an estate plan, you work with someone who really understands Florida law to make sure that everything is done properly. So I'd say the biggest... Yeah, of course.
Sorry, that's why people listening. Every state has their own rules when it comes to this estate planning and trust. It's just, obviously there's the federal, but then every state has their own. I just want to make that so people understand why we're just talking about Florida in particular. So it does not apply to Tennessee. If you're listening in Tennessee, you may need to get a professional in Tennessee to help you out with this. But this is good information either way.
Yeah, no, such a good point. And so many of the things I'm going to say really apply to every state in the United States. It's just that every state has its own nuances and laws. And then, of course, you have federal tax laws that kind of govern the whole kit and caboodle.
Of course.
So in general, in every state in the United States, the biggest things you want to think about as a homeowner when you're thinking about estate planning, one is probate avoidance. It's not the most fun, sexy topic to talk about, but when we explain to clients what a probate is, or when they've maybe gone through it with a family member, they're like, I don't ever want to put my family through that. And essentially, for those who are listening, who are like, what's probate? Maybe I've heard of it, but I don't exactly know what it means. It's basically the court process that if someone passes away and they either don't have an estate plan or they don't have an effective estate plan, in order for the assets to get from the person who passes to either those named in the estate plan, or if you don't have one based on the laws of the state where you reside, it has to go through a court process. And in Florida, you have to hire a lawyer, which gets very expensive. Usually you're waiting a minimum of 6 months, often much longer, for assets to then transfer easily. And if someone's trying to sell a home, for example, like when we're on that topic of the home, that can be devastating at a time when you're already grieving the loss of a loved one. You might even try to get a property under contract, and all of a sudden you're like, oh crap, it's in the name of the estate. Can't. Deal falls through. So frustrating. Dealing with sales and purchases of real estate, when you have Matthew on your side, I'm sure it's so much easier, but it's hard. It's frustrating.
It's true. It is much easier when I'm doing it.
Yes. That's
it's
what I've
very
heard.
Stressful. Yeah. I have dealt with it over the years as personally, but also as a real estate agent on that side, on the listing side, listing an estate property that has to go through probate. Like you said, it's a minimum 6 months of time, but something I think that's overlooked, and we were talking why you want to do these estate plans, because 6 months in the span of life sure is short. It's not a lot, but the market could change drastically in 6 months. So you could lose the family could be losing value in the property at that time. Hopefully it doesn't. But look, there's unforeseen circumstances like 2008, and everything went excuse my language, went to hell in a handbasket. I was in the business already at that point 10 years. So you want to protect the value of the asset as much as possible. So that's why you and others who deal with this particular side of law are critical in helping preserve the asset. So continue. Sorry, I just wanted to throw my 2 cents in there about protecting the value of the property, especially.
Yeah, no, it's such a good point. And especially even now with the market the way it is all over the place, we don't know. We don't know. It's probate is just an unnecessary inefficiency financially, emotionally. It's not fun. We hold our clients' hands through it. We just see them like, oh, I have to fill out all this stuff and I have to do all these things. Why couldn't it just happen automatically? And when there's a really good estate plan, it does. It happens in some ways.
Transfers.
Fairly automatically. So probate avoidance is a really big one. Another thing is making sure the right people get the right assets in the right way. So if it's a surviving spouse, usually it's just, they're just going to get, if it's a home, they're just going to get the remaining interest. But then what happens? Then who's going to get it? How are they going to receive it? If you want your children to receive it, are they going to receive it in their individual names? Now you have, let's say you have 4 kids. Now you have 4 co-owners on a home and they can't decide what they want to do.
I've actually seen that on the title. 4 different names, 5 different names. And let me tell you, filling out that contract's a pain at that point.
Yeah. And what if they don't all decide? So we'll talk about will versus trust and all of that, but that's in a trust. You can say, here's what happens, or here's who has a right of first refusal, or whatever you want to do with that property. That's another big thing that we see, just making sure the right people get the right assets in the right way. And that's important for any family, but especially if there's a blended family, meaning you have children from prior relationships. Oh my goodness, please go call your estate planning attorney right now, because it can get disastrous, truly.
100%. I've seen it happen. I'm watching it now happen in real time, not with a potential client who had engaged me over a year ago. And they're fighting. It's a blended family and they're fighting. And as they're fighting, now you're talking almost a year and a half, soon to be 2 years of time, the value of that condo, because condos have been rocked in the last now year and a half, has gone. They could have made some decent money, and now it's slowly declining value because of the market conditions. And it's very unfortunate because there's less and less now to divvy up between everyone.
Yeah, not to mention legal expenses, heartache of having to fight, special assessments. That sounds like not a good situation. And we see it all the time. Even if families get along, we see it. So it's so important
100%.
To make sure that you have a good plan in place. Another thing that we really emphasize is tax efficiency. So we'll see sometimes clients will come in and either they've already done this or they're about to. They're like, oh, I'm just going to add my child to the deed because I heard that avoids probate. And it can. If you put the rights of survivorship on there, we've seen that too, where you have it as tenants in common, and we're like, yeah, you avoided probate on the portion that they own, but not on the portion that they inherited. But the big thing that we see is then tax inefficiency, because if someone inherits, let's say I pass away and I bought a property for $100,000 and now it's worth $1 million. If I gift that property or a portion of that property, the person who takes that is going to get my basis. Let's say I never did improvements of $100,000. So if they sell, they have to pay capital gains tax. If they inherit it from me and it's worth $1 million on the day that I pass, they get what's known as an income step up in basis from a U.S. federal income tax perspective. So now they get a basis equal to my date of death fair market value of $1 million. They sell it the next day, zero capital gains tax. That's a huge difference, especially in that type of game.
Absolutely. I've actually a couple times had to do what they ask for the value at a certain time, whenever they purchased it or when they changed the title. Hey, my in-law bought this home in 2008. What was the value in 2008? Can you do a CMA or comparative market analysis to find the value? And then based on from, say, 2015, when there was a change, what's the value now from then on. So I have actually worked on a few of those, and for me it's fun because I love to do that stuff. It's a little bit of it's investigative work. It's a little bit like I get to be a detective, but I love putting together the values and doing that work. That's something when someone calls me, I'm like, oh yeah, I'll do that. I love doing those.
Yeah.
But yeah, when you're talking about the step up from how to save the money, yeah, you don't want to get the basis when we bought it for $100,000 because then I don't know if do you even get an exemption up to a certain amount of money, dollars before that, or
not
$900,000.
Not unless the beneficiary was living it as their primary residence for the 2 out of the last 5 years.
If they were married,
yeah.
So they don't get even that. So it's your basis on $900,000,
and you can't 1031 it because it wasn't an investment property, so you're just SOL. It's not great, and we see that, and sometimes we catch it before it happens, and sometimes we undo it for the client because we're like,
just out of curiosity. You said you couldn't do a 1031, but could you do a deferred sales trust on something like that, or is that also not applicable in that situation?
I'd have to double check, but I don't think so. I don't think you'd be able to do that.
Probably not, but
I don't think so.
I just wanted to sound smart for a second.
I like it. And there was
I'm throwing out things I have no idea about.
Yeah, it's a good point. I'm sure you've dealt with it all the time. There was one other point. Yes. Yeah. Oh, go ahead. Yeah.
Not deferred sales trust. I haven't really dealt with those, but I've done 1031s and things like that. But deferred sales trust is something I think is now you're seeing a lot more talk about it, as far as a tax savings plan. Because if you don't want to own real estate again, it's one way of not having to do a 1031, but having to put the equity away for a certain amount of time or reinvest it in a JV or partnership or do a finance type of deal. That's another way. But I'm not sure if, like you said, you were not sure if that's going to actually apply in these situations. Yeah.
You'd have to check. And then the other thing I think that's really cool to bring up is if in that estate planning, you're leaving assets in trust for, say, children, grandchildren, other beneficiaries, you've now given them the gift of a prenuptial agreement for those assets. You've given them creditor protection, and you've kept it out of their estate from an estate tax perspective. So that's huge. That's when you get into generational wealth, but you don't have to be super wealthy to do this planning. That's what's so cool about it.
Because now with the new, they extended the tax break on you're exempt. I forget how much now. Is it 15 million or something like that?
Yep. Exactly. So you can
God
give
bless
away,
you if you have that kind of money.
And it's for a married couple, it's 30 million. So you can give away or die with at the federal level 30 million if you're a married couple, 15 starting in 2026. And that's at the federal level. Florida, if you're in Florida and you're listening, we don't have a state level estate tax, but other states like New York, they have a lower state level estate tax. So just because it's 15 at the federal level doesn't mean all states follow that. So that's something you want to look into as well. But we don't know what it's going to be in the future. It's permanent, but it's only permanent until another administration changes it.
Administration and Congress decides it's not permanent. Yeah. Absolutely. You're right. Permanency is only dependent upon who is in office at that point in time. Mm-hmm. Correct. That's a good point. All right. So we continue. Let's get into how other ways you can help in protecting the assets of those people you help.
Yeah. So like I was saying, a revocable trust, if you're not super high net worth or you don't have really significant creditor protection needs like a physician, then you might want to do more complicated planning, which is irrevocable trust planning, things like that. We can talk about that. For most of us, though, the starting point, for everyone really, the starting point is typically a revocable trust. Every now and again, we'll get someone that comes in and they're like, I need a trust. And we're like, you don't. You can do a will. You can do an enhanced life estate deed, also known as a ladybird deed, which is basically in Florida, a beneficiary designation on real estate. Not every state has that, but Florida, we're lucky.
I'm glad you brought up the ladybird because I hear that. Oh, sorry, my camera just fell. Oh, okay. I hear that a lot. Like, oh, what about a ladybird? And I'm like, I think some people, no offense to those who, but it's always like, oh, ladybird. And I think they're trying to make it sound like they're educated on something they don't know anything about. And I'm like, do you know what a ladybird is? I'm like, oh no, I heard it somewhere. But I like that you brought it up because I hear that a lot. And it's usually from people who don't know what it means exactly. Mm-hmm. If you want to just give a quick explanation of that, please do.
Yeah, absolutely. So essentially in Florida and a few other states, we have what's called an enhanced life estate deed. So back in the day, and for still many states, you have traditional life estate, which means I keep my life interest and I gift to Matthew a remainder interest that he takes when I pass. That's a gift. I've made a gift to Matthew. I have to file a gift tax return potentially. You're so welcome. But in Florida, we have what's known as an enhanced life estate deed. Lady Bird deed is just a nickname, but it basically says, I give my property to Matthew if I own it at my passing, right? So if I still own it, I can sell it. I can take a HELOC out on it. I can do whatever I want. I can change the beneficiary if I get mad at Matthew. But otherwise, it just avoids probate. It gets a step up in basis. So it's a very easy planning technique. Either one, if the person doesn't need a trust, or two, let's say each spouse has their own revocable trust. Oftentimes that makes sense from a tax perspective. So that way you can name the enhanced life estate deed beneficiary as one of the trusts, for example. It's a really handy tool if someone has a mortgage, because it doesn't result in the imposition of Florida documentary stamp taxes. Typically, this is not tax or legal advice. Consult your attorney. But it doesn't typically result in doc stamp taxes, unlike if I have my home where I'm sitting right now. If I moved that into my revocable trust, I would have to pay doc stamp taxes on the mortgage amount. And I may not want to do that.
Even if you already have even if the mortgage is already existing, you have to do it again? Really?
Yes. So if I have a home owned free and clear and I'm transferring it to my own revocable trust, no, Florida law says no doc stamp taxes. If I'm transferring it to my revocable trust, but I have a mortgage, that's when documentary stamp taxes come in. And it may be, I don't know, $4,000, but people already don't want to pay $4,000 for an estate plan, so they're probably not going to pay $8,000.
They don't want to pay the state $4,000. I can tell you that. That's
exactly.
Sure.
Exactly.
They don't want to give. Yeah, no one wants to give away money if they don't have to.
Exactly.
Talk a little bit about building generational wealth through the legal strategy. I saw on your website a few things you mentioned it. I just would like to hear more about it, please.
Yeah. So a lot of it ties to what I was talking about, the trust planning. So I'll get into that in a moment and expand on that a little bit more. But I think also it's just sitting back and actually looking at your financial situation. So estate planning feels doom and gloom, I think, to many people, but really it's just an extension of your financial plan. So it's starting with, what do I own? How is it titled? What type of asset is it? And have I named beneficiaries? Because what we see all the time, we do a lot of probates at Flourish Law Group. We'll see people have brokerage accounts, they have bank accounts, sometimes life insurance, less often, houses, real estate investment properties, and there's no beneficiaries named, or it wasn't moved into a trust, and boom, that's when probate occurs. So you're already reducing the ability for your next generation to build generational wealth, because you are resulting in probate fees, time delays, potential value of asset going down, fighting, all of those things. So that's like the starting point. Understand what you own, talk to an estate planning attorney, get a feel for what it is you need to do. So maybe you need to save for that investment or just wrap your head around it. But I really fully believe that so many people ignore their planning because they just don't know. And I believe that having a healthy money mindset involves having an estate plan, whatever that looks like for you, based on what you need. And a good, honest estate planning attorney will tell you what they think you need. They'll make a recommendation. They won't put you in something more complicated than you should be in. They'll give you the pros and cons, and then you go from there. Great. So that's where I would start.
Okay. Then what about, is there any other things you should be doing? We talked about, for the maximum tax efficiency, this is something I have heard people on this side of the law as well, and I've assisted on one or two deals on Medicaid planning and elder care. So obviously that's a big part of our demographic here in South Florida and Florida in general. We have an aging population across the country, and you have to think about the elder care, long-term care, and Medicaid. So is there a planning or a strategy that's involved in that?
That's a great question. And all of these topics are just going to become more and more relevant as we move through this, what they're calling the great transfer of wealth. But I do think that over the next decade or two, Medicaid planning is going to become even more prevalent than it is now. because the reality is the cost of living across the US, but especially in places like South Florida, it's very high in general, but then the cost of long-term care, nursing homes, memory care it's astronomical. And if you have a family that has done well and has their nice nest egg that they intend to go to their kids and their grandkids, we're going to see a lot of people blowing through that just trying to pay for those cares. So there's a
I
lot
think
of
you're starting to see it
people.
now.
Oh yeah.
You're seeing
Oh
it now.
yeah. Yeah. We're doing Medicaid planning for a number of our clients because even if they still have full capacity, we've seen this every now and again recently where a couple comes in, the wife is still fully with it. And these clients are on the younger end, maybe 60s, early 70s, but the husband is starting to show the very, very beginnings of a decline. Still totally with it, still full capacity to do planning. So we're then explaining what you can do. There's different things that you can do. If it's in advance of needing the care, you can make gifts out of your name into irrevocable trusts. You want to make sure, though, that you're not running afoul of there's a 5-year rule that then starts a time period that you can't get Medicaid. So if you're well before the time that you might need Medicaid, which is essentially paying for long-term care, home care, memory care, whatever might be needed for someone who has the need, the financial need, you can do that planning ahead of time and start moving assets out of someone's name. If you think they might need it sooner than the 5 years, there's many other things that can be done. Your homestead is not an asset that count against you for Medicaid. Investment properties that are rental income generating are not there. They don't disqualify you from an asset side because when you're applying for Medicaid, you have to show your assets are under a certain amount and your income is under a certain amount. So you're toggling between the two. But investment properties are a great way to shelter money, put them into real estate, and then you can shelter the income through various Medicaid planning methods as well. There's also things called caregiver agreements where, I need Matthew to care for me and I want to transfer him $500,000. So now I have very little in my name. I can apply for Medicaid, totally legitimate. It's not a gift for Medicaid purposes. A lot of times kids are already taking their parents to doctor's appointments and shopping and all of these things. So there's legitimate ways to apply for Medicaid or prepare yourself to apply for Medicaid, and a good trust and estates lawyer will either know those methods or they will be able to co-counsel with someone. And we're just going to see this, more and more. It's just another aspect of estate planning and another way to build generational wealth because you can save all of those funds for your kids and your grandkids rather than spending it all down, which, that can be unfortunate.
Yeah, I've seen it before. I hear about it because of the Medicaid clawback. And if your asset, I think if you have too much cash, you don't want to have too much cash on hand.
Right.
That's really, I think that's what I've learned from that because I helped in my own personal, not anyone in my family, but I helped an attorney who's a Medicaid elder care expert specialist in the law, and he had a client, and he contacted me and said, "Hey, look, we need asset protection for this gentleman. He has plenty of cash, but he doesn't own anything." Mm-hmm. And like you said, is either putting in a family name, using that cash with family to buy property or buy investment property. And that's what they did to protect asset protection. Again, we're talking here to also preserve what he earned and worked hard for. So he can be able to now to give it to his kids so they can have the benefit of that. So that was really interesting for me to work on and to help with, because at the end of the day, look, I always feel pretty good about what I do and my transactions. But this one felt good because you're helping this gentleman avoid losing his money and also at the same time helping him build for his family that he didn't do early on, but now he had the ability to do it, which was really nice and special. And look, the laws are there to protect those people, and you help people like that on the elder care side.
Yeah.
This is wonderful. The law's there. Use it.
Use it. Yeah. And like I was saying about a trust, if all of those rental properties were held ultimately by, let's say, a revocable trust while that gentleman was living, that then becomes irrevocable when he passes away. Now you have an irrevocable trust for your kids and your grandkids. That goes back to what I was saying. You're effectively giving them a prenup for those assets. You're giving them creditor protection. While you're alive, if you have a revocable trust, you're not getting creditor protection on that trust because you can take the assets out at any time. So it's a flexible estate planning product that is still very important, but it doesn't give you that creditor protection. You might have the properties in a limited liability company, better yet with 2 owners, to have really the ultimate creditor protection on that property. But your kids are now inheriting it. They don't own it. They could be their own trustees with certain provisions in the trust, but they have creditor protection, tax protection, not income tax. Someone's always going to have to pay income tax unless you're doing cool things like 1031s. And you can definitely defer, or you could even fund different charitable vehicles where you're putting in $100,000 to reduce your income tax liability, but then you don't actually have to distribute that $100K to the charities right away. There's so many cool things that you can do, like donor advised funds. There's so many things. So I think it's just, even for those of us, again, who don't have the 30 million, the 50 million, the billion, even 10 million, there's still things that are super impactful to our wealth, our planning, and our family's wealth. And I think that's why I love what I do, because I'm like, it's not that complicated oftentimes, but it's just tweaks. It's knowing the law and knowing how to title your assets and plan accordingly. And then implementing. I always say we're professional nudgers. That is our job. I have to have a high.
Nudgers.
It's true, because it's a mental hurdle. It's a mental hurdle to get all this stuff done. You're asking people to think about scary things. But we always tell our clients, we're planning for the full life cycle, the full happy long life. We're just having a plan in case something happens sooner than anticipated, which.
And I think there's, like you said, professional nudgers. I think, unfortunately, there are people that get scared by this. They're like, they think there's some kind of finality to what they're doing with estate planning, which, like you said, they're not. It's not a finality. It's just like an overall, general, holistic part of everything that you're doing as far as investments or you're protecting yourself or your assets, or be able to build upon those assets still. You're not dying doesn't mean you're going to die the next day once you do your estate planning. It does not mean that. When you're dealing with people in estate planning, is it advisable for those who are younger, say just starting out or buying their first home, to get a plan, at least a plan in place or something in place at that time?
I'll do you one better. Really, anyone who's 18 or over should at least have a power of attorney and healthcare documents. Because let's say my kids are really little, but let's say one of them turns 18 and he's going off to college. It used to be that I could just call his doctor and ask for his medical information. He's now an adult. Mm-hmm. I can no longer do that. So let's say, and I've had this happen to clients' kids, kid gets hurt at college. Now they're in the hospital. You're calling frantic about what's going on, and they won't give you information. They might, but legally they are not supposed to give you any information. So if your children have named you as in Florida, a healthcare surrogate, in other states there's other names, healthcare proxy, healthcare power of attorney. Now I can call the doctor and I can get information. I can make decisions. Financial decisions. I can move money from a bank account. If my child's, hey, I don't know how to pay my bills yet. I hope my kids by then will have an idea of how to pay a bill, but I can assist them with their financial planning or their financial decisions, in case needed. So really, 18 or over, everyone should have something in place about who can make financial decisions and healthcare decisions. Then once you start acquiring assets and having children, you're just refining that plan. You're adding to it. That's probably once you have kids, you need a revocable trust. Bottom line, minor children cannot inherit. They legally cannot inherit. So if you don't have a trust and they're inherit, let's say, God forbid, something happened to me young. Now my kids are getting these assets at age 18. No, thank you. I don't want my children inheriting my wealth at age 18. I think back when I was age 18, I thought I knew everything. Now I'm almost 40. I'm like, I don't know anything.
Let me tell you, that's very true. I would have been a disaster. It would have been, oh my God, 18. I would have blown through it in the first night.
Forget it. Exactly. Yeah. So it's just, it's those little things that we say to clients. They're like, oh, I never thought about that before. That's a really good point.
So true. So true. I'm just curious, if someone has assets in other states, other properties or assets scattered around, How do you put that all together in a state? Because now you have different state laws overlapping, along with obviously the federal. But we had mentioned it earlier that not all states have the same rules. But if I say come to you and say, "Hey, Lauren, I have this house here in Miami, and then I have an investment property in Oklahoma, and I have something else in Tennessee," how do you make that all come together or work just from the estate planning part?
Yeah, and even other countries. It's a great question, and it happens all the time. Just this morning, I was connecting with a New York attorney for one of our clients we're only Florida licensed, who they reside here, but they have a condo that's a rental property in New York. Right. So really, it's the home-based attorney's job, truly, I believe, to connect with counsel in other jurisdictions and make sure that it all aligns and it works together. But oftentimes, you can move property in another state into a Florida revocable trust, or you can do other planning on those assets, like other states have. Some have enhanced life estate deeds or other life estate deeds, depending on. Right. But it's our job to connect with those attorneys, get the client on the call and say, okay, here's what we're planning. How does this work from your perspective? Or if it's another country, how does this work from a Florida perspective? And get everything aligned to make sure that it is. But it's not necessarily complicated. It's just putting the team together or working with the client's existing team to make sure that you have an efficient plan in place.
Understood. Okay, makes sense.
Yeah.
Just when an investor is buying property or assets in real estate, you always hear LLC versus different types of trusts. LLCs, I can understand why you would want to use an LLC when you're buying an investment property. I get that. Well, that's not your primary home. How do you advise a real estate investor or just anyone who's buying, saying, "Oh, use a land trust, use an LLC"? What do you tell them? Here's the reason why X, Y, and Z to use these instead.
Yeah, so I think it always starts with any engagement. What are your goals and objectives with this property? And let's say it's just a traditional rental property or short-term investment property. Now you're not dealing with a homestead, right? So when you have your homestead is in Florida, is an incredible asset protection tool that really protects from most creditors except the IRS, or if you don't pay the guy that or gal that does your roof. It's a really great protection, which is why so many people come down here and buy these really big mansions.
Absolutely.
To get their money protected. And there's obviously issues with that sometimes. But if it's not a homestead, if it's an investment property, then it's really understanding first, is there a mortgage on the property? If there's a mortgage on the property, or if you intend to finance, I should say, that's going to make it a lot more difficult to get financing in an LLC. So it's understanding, okay, what is the structure in place? If you're able to take title, let me take a step back. A lot of people will recommend just taking title in individual name and then transferring to an LLC. I'm always very hesitant about that because technically that triggers a due on sale clause, typically in the mortgage, which means the lender could then say, pay me my money.
Right.
That scares the crap out of me. So I always tell clients, like, if you're going to do that, I have advised you may not want to do that. But let's say there's no financing or it's non-traditional financing and you're able to take title in an LLC. Now you're deciding, is it a single member LLC? Is it a multi-member? Because if it's a single member, you're only getting some creditor protection because let's say it only really protects those underlying assets versus protecting all of your assets. So having a multi-member LLC is much more effective from a creditor protection standpoint, but it gets more expensive. Sometimes people don't have a second owner that they trust, so they have to create an irrevocable trust as that second owner. So again, going back to goals, objectives, net worth, it's so fact specific, but just different things to think about. You might have a revocable trust at the top of this structure, but remember, a revocable trust does not give you creditor protection. It's a probate avoidance and estate planning tool. So you're going to really want to explain to your trusted estate planning attorney, here's what I'm trying, and maybe a real estate attorney too. Here's what I'm trying to accomplish. Give me the pros and cons and recommendations. There's also land trusts in Florida. So land trusts do give some creditor protection. They're also great for anonymity. So if you don't want people to know your name and who owns the property, you can name another person as trustee or individual entity as trustee to hide yourself, especially that's really important for a lot of celebrities. Florida Panthers, call me. I really want to work with you. For people who really don't want people to just look them up on Sunbiz or on the property appraiser website, which is often very easy to do.
I do it all the time because I want to know who I'm dealing with, or they're the right person who they're saying, hey, I want to list my property. Okay, great. Let's make sure everything's correct. One thing What if the heirs don't want the property? They don't want to inherit what it is. What can be done?
Depends how they're taking title. So if they're just receiving it in their individual name, let's say it's just one person, they can obviously just sell it. If it's in multiple people's names and they don't agree, that's where things can get a little iffy. But if it's in individual names and everyone agrees, totally fine. Let's say it's in a trust and the grantor gave the trustee and the beneficiaries full discretion. It's just the trust selling the property instead of the individuals. And it might be the beneficiaries as their own trustees, but then when they sign the deed, they're just signing as trustee rather than in their individual names. And if it's in an LLC, then it's the manager who's making that decision. So it just depends on the structure. Yeah.
Right.
Yeah.
I just curiosity. Can a trust be contested? A will can be contested?
Yeah. So a trust can be contested. Now it's often a little bit less likely because when you have a will and there's a probate, all of that information becomes public knowledge. So people can come out of the woodwork. When it's a trust, it's a private document. But yes, there can still be trust litigation over inheritance, the same issues that come up in wills, incapacity, undue influence, depending on what the circumstance was. Maybe you have someone who their caregiver made them think they were in love, and then all of a sudden the kids are getting nothing, and the caregiver is getting.
You hear that a lot.
Oh my gosh, it happens all the time. It does. Or maybe it's just families not getting along, or kids think they got screwed somehow. You can still contest a trust. It's just it's more private, so it's a little bit tougher. But if it's the trust beneficiaries, they're entitled to the trust document typically anyway.
Gotcha. Understood. As a real estate agent, what do you tell real estate agents, or you can give some information to real estate agents when they're advising clients or buyers or sellers on their estate planning? What's something that I and the general population of real estate agents should know going in?
Yeah. If it's a homestead and it's a single buyer, asking them if they have a revocable trust, because if they do, then they should just take title in the revocable trust, because then you don't have to worry about that doc stamp tax issue I mentioned. Let's say my realtor didn't know I had that trust. I take title. I want to transfer it to my trust. Then I have to pay doc stamps again. If I just take title, we don't have to pay twice. So understanding what estate plan the client already has, I think is crucial. And then having a connection with one or more great estate planning attorneys, because it's like anything else, matchmaking, and introducing them to your client and saying, hey, just do a consultation. If you don't have a plan, or if your plan is 10 years old or 30 years old, get an understanding of, before we actually close on this property, how you want to take title. Get an understanding of the person's goals, because oftentimes there's really no reason for the real estate professional to ask these questions, because you're doing the deal. That makes sense. Right. But I think it's a huge value add, and it can make everyone look really great to say, hey, I have this connection. Just have a conversation with them. They might give you some insights on what you can do today or what you can do in the future to make sure that you are protected. If you have foreign clients, especially this comes up in South Florida a lot, it's definitely really important to talk to an experienced tax attorney who deals with international tax, because we talked about the $15 million exemption that's for U.S. citizens and permanent residents. But let's say someone's coming from Spain or Colombia and they're buying the Brickell condo. They only have a $60,000 exemption on U.S. cited assets. So if you have Apple stock, or if you have a condo, you're going to exceed that. Now your estate is going to have to file a 706NA for non-resident aliens. Your family is going to have to pay estate tax. If you're in a country that maybe you're scared of the government and you don't want U.S., it happens, like Venezuela.
You're not laughing, because it does happen. It's so common here in South Florida, especially.
Super common.
Everyone's from somewhere else for the most part. You have a lot of people who come here for protection, from either whatever it may be, and they may not want to know they don't want people from where they came from knowing what's going on. They want to protect themselves, and which is understandable. I get that. That's completely understandable. And and obviously in real estate we have FRIPA, but I think there's ways to get around those things. Obviously, like you're saying, however you put it in on the deed, or how you structure the deed, or in a trust or an LLC, there's ways of avoiding some of those things.
Or a foreign corporation that owns a U.S. corporation, so you're blocking that from estate tax. There's so many different things. I think it's so cheesy, but knowledge is power and knowing what you're doing before you actually even sign the contract for sale. Because talking about FERPTA, if you then transfer that to the new buyer, let's say I'm like, oh, I don't want to take title in my individual name. I actually want to take title in a foreign corporation. Just the transfer of the name on that contract for sale technically is a FERPTA transfer. So it's like anything else. Just talk to people, talk to professionals before you do anything. Have your team in place before you do anything so you avoid costly mistakes.
Yeah, and you said the team. That's important because I've had plenty of foreign buyers and sellers, and especially on the buy side, when a good attorney who's on the real estate side knows what they're doing, they're going to ask a lot. I've seen it. They'll ask, "Hey, how do you want to take title to this property? Since you're either from Canada or Colombia or Venezuela, wherever, or Europe, Germany, to avoid the FREPTA, especially how it comes up." And then, if you're good at what you do, you'll ask. That's again critical to have a good Rolodex of professionals there that you can trust and who you can count on to give good advice to your clients. Just to put it all on a nice, neat bow, just give us a quick summation of this, all what you do and advice that you give to your clients.
Yeah, thank you. Like I said, we really focus on estate planning, which, as you've heard in this episode and seen in this episode, encompasses so many things: tax planning, Medicaid, international aspects, planning for your children. It's all under that kind of umbrella of estate planning. So what I would leave everyone with is, if this is something, like so many people come to us, this has been on my list for years. If this has been something that you're like, I really need to get this done, I really encourage you, schedule a couple consults with some estate planning attorneys, get a feel for who you like, get an understanding and kind of compare what each of them are recommending, and then take action. It's the hardest part, and why we are the professional nudgers, is just taking action. Your family will thank you. You will feel so much better. You will feel wealthier because you're like, I'm making wealthy decisions, not avoiding things or procrastinating on things. And I believe that once you make one wealthy decision, it leads to more. And I think that can actually change.
I love that line.
Yeah, I believe that.
It's a mindset.
It's a mindset.
It becomes a mindset. Yeah. And I think the important thing is that people listening to this is, you don't have to be a multimillionaire or a billionaire to have an estate plan. You do not have to be one. It applies to everyone across all income levels, all wealth levels. If this is something that is important to you as an owner of property or whatever your investments in general, and you want your family to benefit from the hard work that you put in life and you have accumulated, hopefully everyone does well, but it does not matter how much you have in the bank. It's still something worthwhile to check out and to have a plan. Talk to a great attorney like Lauren or anyone else that you feel comfortable with. This is really good advice and actionable advice for people. Lauren, how can people find you at the end of the day?
Yeah, so we have our website, which is flourishlawgroup.com. I'm also very active on Instagram at Lawyer Lauren Klein or at Flourish Law Group. And of course, all the other social media platforms, but would love to connect. We have contact us forms. If you have any questions, if you want to schedule a consultation, you can do that on our website. And if you want to email me, let's say you're sitting in another state and you're like, okay, that's great, Lauren, I'm not in Florida. I can connect you with one or more great estate planning attorneys in another state. So you can always email me, Lauren Klein, LAURENKLEIN at flourishlawgroup.com. That's flourish like a tree, like flourishing.
That's it for today's episode of the Krinzman Property Playbook. I hope you've gained some valuable insights and feel inspired to take your next steps in the real estate game. If you're ready to make a move or need expert guidance, let's connect. Whether you're buying, selling, or looking to invest, I'm here to help you navigate the South Florida market with confidence. You can reach out to me directly through my website or on social media. Let's get the conversation started and make your real estate goals a reality. Thanks for tuning in, and I'll see you next time on the Krinzman Property Playbook.